Mr Lees.
Morning, my lord. My lord's, a bit of housekeeping, or rather homework reporting. We looked at the question of delivery. Both have looked at it independently and spoken to each other. I think the agreed position, I don't know if I'm wrong, is as follows. Delivery doesn't require either the imparting of the document to the recipient or indeed anyone else, nor does it require the giving up of possession away from yourself. It is a unilateral act which is concerned with the question of intention and intention to be bound by it. There's also a helpful, again, as we're agreed, we've not troubled you with it, but there's some helpful authority, slightly older authority, which indicates it's not only a unilateral act, it in fact can be an act that occurs with no one else present. There's a discussion, I think it was a Lord Denning judgment, which talks about putting your finger on the document and saying, I'm delivering this as a deed to the heir, is potentially sufficient. So that, I think, is an agreed position. And so delivery isn't an art. To go back to my Lord's example, one could have a suitable deed executed in a drawer, and that would mean it could still be delivered. It's right to say that delivery does have to take place last. So it is, one can't deliver a deed that hasn't already been executed, or one can't deliver a deed. It can be part of the same process, but you can't have a non-signed deed in a drawer. That wouldn't work. And delivery can be inferred also from conduct of the parties as well, where necessary. There are some provisions in the Companies Act that we had a look at. I haven't discussed this with my learned friend, which in fact deem in certain circumstances delivery to have taken place contrary to the contrary intention being evidenced. I don't think it's going to help your lordships to go through that in any detail, but that's the result of our homework. So I just thought I'd report that at the outset. The second bit of homework our end, I referred yesterday when dealing with policy or how the code's structure is supposed to be worked, that there was a reference in Compton Beecham I was going to give you. That's in the authorities bundle. It's really Lady Rose's judgment, paragraphs 10 to 31. I'm not proposing to take your lordships to it now because it's quite lengthy. Paragraphs 10 to 31, it starts at page 214 of the first authorities bundle, tab 10. But Lady Rose gives a general summary as to the independent parts of the code, how they're supposed to work, and your lordships may find that helpful as a summary and guidance overview. Before I launch into part 5, which is where I said yesterday I was going to, there's just one small point of clarification I'd like to flag at this stage, which is the issue of the difference between sharing a code right, being present sharing, as opposed to being the operator who, for example, is a party to the code right. And we need to make that distinction. And the point I wish to make, I don't think this should be controversial, is the code does not govern or regulate what we call blue-on-blue relationships or blue-on-blue arrangements. That is between operators. So the classic scenario, though it doesn't need to be this, would be a WIP, which, as my learned friend rightly outlined yesterday, is a wholesale infrastructure provider who provides, talking at a general level, passive infrastructure. They provide sites with passive infrastructure on it to which active ECA is attached. The code does not regulate those relationships. So in talking about licenses between a WIP and an operator, for example, or one M&O and another, were they to share, if the M&O owned the passive infrastructure and we're going to share it, those relationships are regulated by Ofcom, and there's a separate procedure for that. That's not governed by the code. Again, I don't propose to take your lordships to it, but one can see that in particular from a combination of 3 paragraphs, which is effectively the definition of land. So you will have seen yesterday in paragraph 3, I'll give you the references, but I don't propose we go to it now unless we need to, which is at page 377 in the authorities bundle, or authorities bundle 2. That's the paragraph 3 is the list of code rights. Those are rights you will have noticed in the main that are granted on or over land. Electronic communications apparatus, ECA, is defined in paragraph 5, which is at page 380. We have both of those in the bundle. We don't have paragraph 108 in the bundle, which is the general interpretive provision. Again, if that's controversial, we can provide that, I'm sure, very easily, or your lordships may be able to find it. But at paragraph 108, subparagraph 1, land is defined as not including ECA. So the code isn't seeking to... so my learned friend's right to say, in terms of who might be physically present or have a physical presence, that may not be a single operator, it may well be a WIP and then a number of customers. But in terms of what the code is regulating, it's the relationship, it isn't the relationship between the WIP and the operators. it's regulating the relationship of the code agreement. And so it's important to note, yes, there will be sharers on site, but the sharers are sharing in the code right of the person I may call the main operator. In this case, it's easier, the whip, because the whip doesn't have, as a general rule, the active infrastructure. It's only the passive infrastructure. So we just wanted to make that plain from the outset, and I hope that helps. If we could turn then to part 5, as I indicated yesterday I would, if we could start at page 419, this is in Authorities Bundle 2, tab 14. We ended yesterday looking at the transitional provisions, and in particular that Parliament had, where I made the point that Parliament had, where it intended to exclude particular types of provisions, had done so expressly in those transitional provisions. That is in fact duplicated here in paragraph 29, where we can see at subparagraph 2, again, the disapplication. This, of course, is a disapplication moving forward, rather than just in a transitional sense of business leases. If we could then turn over the page to page 420 and paragraph 30, this, as was discussed between my learned friend and my Lord Justice Holgate yesterday, this, of course, is the statutory continuation of the code rights. Paragraph 2, it's right to say, continues the agreement. I absolutely accept that. It says so in terms. It's notable we say two facets of that, which are, it's being continued so that from the operator's perspective at A, they can continue to exercise the code right. That's the focus and the purpose of the continuation. And B, aligned with that, it's the site provider continuing to be bound by the right. And we say it's instructive to note, at the very least, what's the purpose of that continuation. What Parliament was in particular concerned with is to ensure effectively the maintenance of the status quo. But in particular, with the ultimate purpose, entirely in keeping with the policy of the code we looked at yesterday, of facilitating network. Ensuring that they can not only remain, but can remain exercising those code rights. My learned friend's right to say, of course, under Part 6, if one didn't have code rights, you might have effectively a statutory irremovability until various notice was served and then that process ran its course. But here we have the code agreement being continued in order that that code right can continue. Pausing here, there was a point which arose yesterday. I, having gone back, haven't seen it being articulated. I'm not suggesting it's inconsistent with my learned friend's earlier case. It's just I don't think it's been fully articulated till yesterday, which was, I think, in particular with my Lord Justice Foxton talking about the liability of the original operator and how long that continues for. It may not matter for the purposes of this particular appeal, but it's not immediately obvious, we say, that the original operator would continue to be bound after the contractual term where there's been an assignment. I note that because, firstly, at the time of entering into these licenses, there was...
Yes, hang on, I'll get this down.
Forgive me, my lord.
Yeah.
Firstly, at the time of entering into the contractual licenses that we're talking about here, by definition, they would have been entered into at a time where there was no statutory continuation. Because as my learned friend rightly said yesterday, under the old code, there was no statutory continuation. There was simply the statutory immovability and the ability effectively to serve another notice or to serve a notice to get a new agreement. But there was no continuation of your old agreement. Secondly, we've had a look at, again, and Lord Justice Holgate will recall from the appeal last year, the 54 Act being used as a model can be taken too far. But under the 54 Act, it's right to say that an original tenant, of course that only applies to tenancies, not to licenses, but an original tenant would not, without express wording, be liable for the statutory continuation tenancy after the contractual term. Now, I anticipate the point might be made, and in order not to mislead your lordships, I want to be clear. There is a potential distinction because under the 54 Act, it's not the contract that's continued, it's the tenancy that's continued. And that's, of course, a distinction that one might make. That's unsurprising because, of course, the 54 Act applies to tenancies, whereas the code, as we discussed yesterday, has to apply to both tenancies and licenses and indeed way leaves, etc. So I only say that of assistance. I'm not suggesting it's in any way determinative, but there's nothing to suggest in my submission, or nothing to answer the question, would the original operator remain bound after the contractual term has expired? It's not obvious in my submission that it would, in fact.
That might be quite important. On this basis, you may have a situation in which what continues is not the original contract as such, but a state of affairs by which the subsequent occupier was enjoying rights at the date of expiration pursuant to that original contract. It is somehow continued as between site provider and
My lord, yeah, well, I accept it might be important, yes. And also I accept that, as I said at the outset of my submissions on paragraph 30, when one looks at what paragraph 30 is doing and why it's doing it, the focus of this paragraph is about ensuring that the person exercising the code right, and I should say there's no dispute here that the person exercising the code right is On Tower as the party in situ with the benefit of the code right. There's no dispute that that's what's happening, and the purpose of paragraph 30 is to ensure that that situation can continue.
I mean, it's an interesting question,
To
to which the answer may not be obvious.
my lord, no.
There's obviously nothing in the wording of paragraph 30 itself to suggest that the continuation of the agreement does not affect the original contracting party. You could also have oddities. So suppose you've assigned the benefit of the agreement for a period.
My lord, yes.
So what happens then? So that at the point at which the agreement comes to an end, I suppose I'm not quite sure what permutations are possible.
My lord, no. And I must, when you were discussing with my learned friend that situation yesterday, although I don't suggest it's impossible to arise, A, I think it is unlikely in practice, but B, it did strike me that had more of the characteristics of a sub-license rather than necessarily an assignment for a time-limited period. Those two things might look remarkably similar, but that, to my mind, was how I think it would be more likely to be analysed. So you do have, I'll use the term reversionary, of course that applies to leases, but you do have that more traditional reversionary situation. I don't suggest it's necessarily legally impossible to do it as an assignment for a period of time, but that would be A, less common, and B, I think, less likely.
And of course, what you're postulating in the case of a license is a situation where, as between the parties, the benefit of the license has passed to the assignee. So there's been no novation.
No, my lord.
So still, as between site provider and original operator, the original operator is entitled to the benefit of the agreement.
Well, certainly on a traditional contractual analysis, that there must be some truth to that, but that isn't A, how it works in practice, or B, I think how anyone's suggesting it's analysed.
No, but the trouble is, in the alternative landlord and tenant world, it works much more sensibly.
Well, of course,
you establish privity of estate and
of course, my lord. Absolutely, and as we'll see when we discuss GenCom, in one sense, it's unsurprising their lordships didn't feel the need to engage that because the law of landlord and tenant was far more closely aligned and sufficiently malleable to work within the outcome they had decided a blind lady raises exhortation was required. That's a different situation, or the different situation may pertain either, as my Lord Justice Holgate posited yesterday, if actually on the site provider side what you have is not a concurrent lessee, but let's call it a concurrent license, depending on what its terms are, or if you don't have an express assignment, if you have a concurrent lessee where there's no express assignment of the benefit of it, but equally where the operator has a license, then it also doesn't, as we've obviously been discussing, doesn't fit as comfortably either.
Can I just say one other thing? So suppose you have the contractual term coming to an end and the original contracting party has agreed to assign to someone else. But the someone else hasn't covenanted with the site provider or potentially with anyone else at all. They have the benefit of the agreement, but they've undertaken no obligations.
Yes.
How does the theory that the agreement doesn't continue work? The original contracting party is off the hook because the agreement is over.
Yes.
Who's got a liability?
Well, the answer, of course, depends upon. I mean, the answer may be no one ultimately, but then then one stands back and remembers the context that I said at the outset yesterday that we are in, which is we're in a situation where the contractual term has ended, and this is maintaining the status quo until either party in the paragraph 33 serves a notice. So it would be open to a site provider, my lord, to do so. So if there were a situation, I mean, in practice, what happens, as has happened in this case, is the operator in situ is compliant.
I'm just wondering whether there is a fundamental problem. Under the contractual agreement, rent is payable.
Yes.
You say, well, maybe it's the case that the agreement doesn't continue in relation to the original contracting party. So who's liable for the rent?
Well, I should say, of course, as per our alternative argument, we accept we would be, because we say paragraph 12 does the job or the principle of benefit burden does the job. But
paragraph 12 may work. It's subject to paragraph 12.
But if they don't work, the answer may be no one. But that doesn't necessarily matter in circumstances where the purpose of the continuation is that the code right continues to be made. If no one is paying the rent, the site provider has the means, as we'll look at in the next provision, to bring it to an end.
Eventually.
Indeed. But equally, if, as is often the case, as is the case here, where you've got two parties who are, to all intents and purposes, complying as if they are the parties to it, demanding consideration, being paid consideration, asking for access, being given access, etc., either party, under paragraph 33, can ask for its modification or renewal. So that is, in fact, the way of ensuring that moving forward, you have that connection.
That won't do, will it? I mean, the contractual term ends. The original contracting party's liability is over unless the agreement continues so far as they're concerned. Yes. No one else has agreed to pay the rent.
Yes.
So for however long it takes to get anything before a court or a tribunal, no one's liable for the rent. Well, that can't be right.
Well, I'm simply saying it's not obvious to me, and in our submission to us, that the liability would, as a matter of general law, continue. It might be, the other point to note is quite often these original people don't still exist anymore. I mean, that's the point Mr Justice Fancourt noted, which is quite often either through some sort of merger or amalgamation, or simply because the operator ceased to function. I mean, in many of these cases, an assignment may have taken place 10 or 15 years ago, and the status quo has been maintained throughout without any giving of a direct covenant or otherwise. And often in these cases, these people don't exist. I appreciate that doesn't answer the principle, but as a practical answer, that is often the case.
Paragraph 5 only works if there's a contract that does exist.
Paragraph 5, my lord.
Part 5. Sorry.
Part 5. Forgive me. Yes, that's right. There is as I say, we don't dispute the agreement continues. That's obvious. Paragraph 30 stipulates that.
If prior to that date, one of the contracting parties had ceased to exist, wouldn't the contract have ceased prior to
well, we say no because the effect of the benefit vesting and there being a code agreement is that the code agreement continues, and then it will continue as a result of the statutes as well. I mean, this may, coming back to your lordship's point yesterday, this is where, in particular in the context of licences, the general law is of assistance, but maybe of less assistance than, as I indicated my lord earlier, the law of landlord and tenant is able to be.
I mean, just to complicate things further, I mean, if it were indeed the case that this legislation potentially produced a result where a site provider couldn't claim rent from anybody, I think there could be a retrospectivity problem.
Well, the argument would also work the other way, because if the intention was not to have a retrospective effect on the parties, the effect of paragraph 30 continuing the agreement and making an original party liable for a period of time for which it could never have known it might be liable, that would also be retrospective. Because the original operator entered into, let's say, a 15-year agreement. not knowing there's the possibility, not even the twinkle in the parliamentary draftsperson's eye that there's going to be this statutory continuation, that would also have a retrospective effect. In fact, the retrospectivity point of my submission perhaps points the other way, because when the original operator and site provider enter into the contract, they both assume two things at that stage. They assume that the contract will come to an end at the end of its contractual term, in accordance with the provisions, and B, they assume at that stage there'll be a statutory irremovability, because they would have known that under the old code, but they wouldn't know anything further.
Yeah.
My Lord, can I move on to paragraph 31? Yes. The following points are good either way, whatever your Lordship decided about paragraph 30, but I just wanted to address that, because it's not something, again, no criticism, my friend, it's not something I think we've discussed below at any stage about that, and that, of course, is, as your Lordship rightly say, may be important. If we look at page 421 then, this is paragraph 31, so this is a site provider only provision, as it were. The point here is in my submission, it is, and Mr Justice Fancourt accepted this as my learned friend yesterday, it is in my submission patently obvious that the party to the code agreement on who it is to be served, and you'll see that at the end of that first provision, is to be the party exercising the code rights. And that makes sense for a number of reasons. It's agreed by both parties, and indeed both the first tier tribunal, specialist tribunal below, and Mr Justice Fancourt, that there can only be one of each. There may be, of course, joint parties who are jointly the operator, but it is, or indeed freeholders, for example.
Well, I was going to ask you about that, because going back to paragraph 31A, if there can only be one of each, that is where we're given the definition of site provider, and it's either someone who confers the code right, or the right is otherwise binding, which seems to be looking at the position of assignment.
My Lord, I would agree with that, and that's most helpful in...
So that might be a simple way of justifying the submission you were making a moment ago.
My Lord does so much better than I do, my Lord,
Well,
yes.
I doubt that.
But my Lord's right. And of course, that's only speaking from the context of the site provider, but that's right. And it is undoubtedly in my submission to be read as one. That's also unsurprising, and I think this was addressed by Mr Justice Fancourt to an extent, and certainly was canvassed an argument below, which is that this has to work not only for parties such as APW, who are sophisticated parties with excellent legal representation at all stages, in-house and out, but this also has to work for individuals. The many, many sites, thousands and tens of thousands of sites, the site provider is an individual. Often farmers for greenfield sites, or it might be individuals who own flats, or there might be companies where their tenants own blocks of flats with a mast on top, etc. So it has to work for those people as well. That's why we all strive for simplicity, which I appreciate is an ironic submission in cases such as this. But it does have to work for them. And just thinking of the paragraph 31 example, because here it's a one-way street. It's site provider trying to bring to an end. When one stands back and asks, who's this notice supposed to be served on? In my submission, it's plain. It's the party who is in situ exercising the code right. They ought not to be that difficult to identify, not least because in practice, and I appreciate it might be said there may be a breach going on, etc., but in practice, that will be the party, and this is a classic example, where consideration is demanded and paid. There will be discussions because there'll be the operator will say, I'd like to install an extra, I'm going to be installing an extra antennae, for example, or I need access via the route that's provided, etc. Some license agreements provide for notice of on an ongoing basis, or request or permissions, or indeed some payment of fees for access, etc. And so is it going to be that person, if I can sort of colloquially say, who my hypothetical farmer can go down to the bottom of the field, I mean, obviously there's no one there to give it to there, and work out who it is. My own friend would say, well, there might be other operators there. That's true, because there could be sharers. There may well be sharers. Indeed, clients like mine and who are whips want there to be sharers because that's their customers. But they still know who the operator is, who they demand the consideration from, and who they engage with. Is it likely to be that person who, A, it's easier to identify, and B, who is the person who is going to have the interest moving forward, either in a modified or a renewed form? Or is it that Parliament intended there to be an exercise of investigation as to who was, just take it, we'll come to some scenarios in more detail later in my submissions, but my learned friend engaged with some of the ones we put in our written submissions, and it effectively calls for, if it's not the last person who's given the deed of covenant, an investigation as to the last person in whom the benefit and the burden vested. My learned friend accepting, that might be a person in whom one or both of those no longer vests, but they're the last person. In my submission, that plainly is not Parliament's intention. So if, as my learned friend does, and as all the courts below, and as I invite your lordships to do, it is accepted there's one person at any given time who's the party to the code agreement, in my submission it's tolerably clear that is intended to be the party in situ exercising the code agreement. Another way of putting that, of course, is with the benefit of the code agreement, of course. So we're not suggesting it's just someone who turns up, of course, with by reference to a code agreement, but someone who has the benefit and is exercising those code rights. We say that plainly fits the bill. The main point that's made, two other points, sorry, I would just make first. One is, as I said at the outset, quite often earlier operators don't exist anymore. Now, that is, of course, always possible with any commercial entity, that it will no longer exist, but in practical reality, if the operator is in situ exercising the code right, I think it's a safe assumption it's going to exist or continue to exist for the purpose of serving a notice. What's the intention of Parliament otherwise in that scenario? Is it that it gets served on the Treasury solicitor? But how are they going to work out that that's the person who last had the benefit and burden? That's going to be hindered by that person not existing. Or even if they exist, serving on an absentee operator, you may not have been at the site for 15 years. The idea that Parliament's focus, and quite frankly the site provider's focus, is on that individual, bearing in mind the context, which is we're post-contractual term and we're focused on getting a modification or renewal, is in my submission fanciful. The best point taken against me on paragraph 31 is, of course, in subparagraph 4. But again, when one looks at it, I absolutely accept, and as Mr Justice Fancourt records, we all accept there's a need for a purposive approach. And the disagreement is simply about the degree of, to use their words, violence that one needs to do to make these things work. We would absolutely accept that the operator in subparagraph 4 should be the operator who's the party to the code agreement. I think that's always been our position, and I think everyone agrees that. The phraseology used, for example, its obligations under the agreement, that may require some degree of purposive interpretation, but in my submission, it makes little sense for it to be that its obligations under the agreement means it must be someone who's acquired the burden. For this reason, this is backwards looking. Yes, this is a provision that says you have committed breaches. On my learned friend's case, and I'll come to this again later, but on my learned friend's case, I only have to give the deed of covenant 1 minute before I serve, let's say a day to be generous, a day before I serve my paragraph 33 notice, I'm slightly skipping ahead, or a day before the paragraph 31 notice is served on me. It would inevitably be relying on breaches that had occurred before I'd covenanted.
Well, unless the deed is phrased to cover
Historic
breach.
Yes, I had not understood that to be my learned friend's case, but that, I agree, of course your lordship's right, it could be worded such as that. As I'll look at later, one of the issues with the alleged simplicity of the deeds of covenant is where deeds of covenant have been given, there's been a significant amount of quibbling as to precisely their words and what they do or don't cover, and what that tends to spawn is the risk of additional preliminary issues. So I'll come on to that later in criticising my learned friend's conclusions. But what I would say to your lordships is there's no doubt in my mind, and in our submission, that it's the same party. It would make no sense for it to be otherwise. But in my submission, applying Lady Rose's approach is if you are persuaded that under 31, the person who you're supposed to be serving your notice on is the person in situ exercising the code rights, the person who we say is most readily identifiable, then paragraph 4 can be read suitably tailored to that.
And are you going to come back to how it's read, or are you going to tell us now how it's to be read?
Well, my lord, so I would simply say, taking 4A as an example,
yes,
that the code agreement ought to come to an end as a result of substantial breaches by the operator of its obligation under the agreement. What I would say about that is, if the operator has not performed the obligations in the agreement. Effectively, it's the word "it's" which is problematic on a literal reading.
Let's say the operator has been paying its rent up the chain.
Up the chain, my lord. Let me
Right.
to the site provider.
To the assignor.
Well, that isn't what happens, and that isn't that. So what happens is the site provider, whether it's the original or an assignee, demands and accepts consideration, as in this case, from the operator in situ. Absolutely no one goes up through old agreements. So original operators, as I've said, depart, and unless they happen to become a sharer, which they might do, so sometimes it's an M&O who then sells its site to a WIP. In those circumstances, it may keep some or may subsequently add active ECA on and say become a customer of the WIP. But in plenty of sites, there may simply be a transfer and they're not there anymore on the site and haven't been for some time. No one, as far as I'm aware, has ever suggested it should be or has been the case that people pay up the chain and then the original person's out of the picture and it's just the person in situ who gets demanded and who pays. I mean, and that's exactly what's happened in this case as an example. Well, these two cases as an example.
So to speak, if you take 4A,
Yes.
ought to come to an end as a result of substantial breaches by the operator of...
The obligations.
So omit it. It still has to focus on the obligations of the operator as a category.
Yes.
So to speak, by this operator of obligations of the operator type person.
Yes, or
it's
simply submit the word "the" for it.
Well, of the obligations, I mean, you still have to identify whose
Well,
obligations.
the operator's obligations.
Yeah.
It could be the obligations of a site operator. I mean, it's very loosely drafted, isn't it?
I know what it is.
Slight understatement. If we go to B, dealing with delays in making payments, the draftsman hasn't thought it necessary to refer to obligation. It's implied that there is an obligation. What the nature of the obligation is, we don't gain much enlightenment.
My lord is ahead of me. That was precisely the next one I was going to go to.
In some ways, this code, irritatingly perhaps, has a sort of is a framework expressed so as to cover a wide range of different situations.
My lord, that's correct, and it will surprise your lordships to know that it's significantly better in many respects than what went before in terms of certainty of what it means. There was a lot less litigation under the old one, but that shouldn't be taken as everyone knew what it necessarily meant.
Just sticking with A a moment longer.
Of course.
So, on this thesis, you could complain of any non-compliance with the obligations of the operator,
My lord, yes.
generically, insofar as this operator was responsible for them.
Well, my lord, for the period in time of which the benefits vested in that operator. So, I mean...
Yeah, that's one point I just wanted to clarify.
My lord,
So
yes.
you can't complain of any...
You can't say
failure to comply
15 years ago
before
there was
they got the
non-compliance and you've only been here 10 years. I think that would be astounding as a proposition. But what's the purpose?
Yeah, but what if you had an assignment which was very recent and the site provider's interest has been damaged by
My lord,
the
yes.
conduct of perhaps a related company then assigns?
Well, I mean, I think my position, my lord, would be that probably you wouldn't. I mean, normally on assignments, I appreciate that's tricky to say in the context of a license. Before my lord reminds me, but normally you wouldn't be liable for arrears before the interest was vested in you. So that I'm not saying it's not open to your lordships to conclude that, but that would be slightly surprising. I think the point I might make is that, of course, the tribunal, in looking, this is about who you serve a notice on and what grounds you can cite, then, of course, the tribunal has to ascertain what to do on the back of that. And, of course, in my submission, it would be surprising if those breaches could have occurred before, I mean, particularly significantly before it was vested in you. But in my submission, what this is, bearing in mind, again, the policy of the code, which is all about facilitating the network and moving people forward, there are only these set grounds a site provider can bring it to an end. And as my learned friend set out, of course, this effectively leads you through to renewal if those grounds are insufficiently satisfied. And so again, if there are, what we have is essentially a temporary problem. We have a batch of sites, admittedly hundreds or thousands of those sites, so it's not a small problem, but it's a temporal problem because they will be transitioned, we say, through Part 5, at which point you will have either through modification or new agreements, which is actually quite often what is required, but I appreciate it could be both and has to work for both, in a situation where this will all become regularised. We know in the future the problem won't arise because of Part 3. So that isn't an issue. This is a short period, but we also know that Part 5 is the way of renewing these agreements, and so that's why Part 5 has to be made to work for this. So it is a temporary problem, albeit in my submission not a small one. Yeah. As my Lord has already indicated, with regards to subparagraph B, the position is perhaps a little easier, given the wording, as the Lordship says, which is rather looser. C, of course, is it's about the site provider then, and their intention to develop. And again, when one looks at D, the operator is not entitled to the code agreement because the test under paragraph 21 for the imposition of the agreement site provider is not met. Well, again, in my submission, that makes no sense if you're talking about an operator who might have left the site 15 years ago. Because again, what's the focus of the code and what's the context in which this arises? My Lord, similar considerations apply to paragraph 33. If we go to page 425, here, of course, as we've already covered, and as your Lordships will be aware from yesterday, this is either a site provider or an operator who can serve this notice.
I mean, just before you go to 32, you can come back to 32.
I wasn't specific.
No, I mean, I wonder whether actually 32 sort of helps you in the sense that if you postulate a situation where a notice is served on the original contracting party who has long been out of the picture,
My Lord, yes.
For 32 to apply, that person has to serve a counter notice and make an application.
My Lord, absolutely, you're right. It does help me.
The 32 stage, you're very much postulating somebody who has an interest now.
Yes, my Lord.
In a non-technical interest.
Who will want to do this, precisely, my Lord. No, you're quite right. Your Lordship is right. So I sort of was slightly aligning with the 31 procedure, but your Lordship's right, it deserves its own attention. Yes, if my learned friends are right, then someone, that may be the original party 15 years ago, or it may be apparently the person who last had the benefit and burden vested in them at the same time, however long ago that was, however divorced from now it is, who is the person who has the right to serve that notice. The person in situ doesn't have the right to serve that notice. The person exercising the code agreement with the benefit of it doesn't have the right to serve that notice. My Lord, that's quite correct.
Because the operator for 32 purposes must surely be the operator who's.
My Lord, yes. It makes no sense otherwise.
Yeah.
My Lord, absolutely right. Paragraph 33 then, a similar point arises, and hopefully I can take it more swiftly. But an operator or a site provider, so it's a party to the code agreement. It can be either an operator or a site provider who then can serve on the other. And as my learned friend rightly identified, it can be either, and it can lead to either a modification or a renewal. And in my submission again, when one thinks about both who the site provider is really interested in, leaving aside the question of historic enforcement for a minute, who at that moment is the site provider interested in? Whether it be APW or be my hypothetical farmer, they're interested in the person who's there who's going to be doing it in the future. They're not interested in a party who used to have the benefit and the burden 5, 10, 15 years ago. And in my submission, that's also true for who Parliament is concerned about. Because Parliament is concerned to facilitate through this code and through this renewals process, continued and improved and reinvested in network coverage, whether there be investment in infrastructure or active ECA and the provision of networks, driving down cost for the benefit of consumers, etc. Parliament's focus is prospective. Parliament is not interested in whether someone owed the money or not 10 years ago, in my submission. And so paragraph 33 works in exactly, we say, the same way. And again, your Lordship's question about paragraph 32 arises in this context as well, which is you have this strange, curious situation where if my learned friends are right, it's someone possibly 5, 10, 15 years previous who has retained this statutory right that when the contractual term ends, that they can serve a notice seeking a new agreement, but that the person in situ can't. My learned friend's answer to that, or the answer he seeks to give, is what he would call, I suspect, a pragmatic one, which is, well, the new person can serve a deed of covenant and bring it all about. But of course, that's not the question. The question isn't simply what's the quickest workaround. The question is, what was Parliament, who, as Lady Rose tells us, who is the person who's supposed to be in the position able to receive or give this notice? And in my submission, that isn't dependent on a step that's not foreshadowed anywhere in the code. It's the person who's exercising the code right, we say, for the same reasons. And that is also clear if you then look at paragraph 34.
Just before you leave 33.
Of course not.
Picking up a point which I suppose goes back to the discussion on 30. Looking at it the other way, it's potentially a bit odd that someone who isn't bound by the agreement can ask for it to be modified when ex hypothesi the modification is going to affect somebody who is bound by it.
Well, I suppose I did think about that yesterday as your Lordship was talking about it. I mean, that would be a reason, if it were the case that, well, I had two thoughts about that. The first is if it were the case that the wrong party were in situ and therefore not bound by it, it strikes me that it's most likely going to result in a renewal. Because I should also say the way this also works, let's imagine my client serves a paragraph 33 notice saying, I keep this agreement going, I like it as it is, but I do want to modify it. It's open to the respondent, whoever that is, a site provider if the operator served it, to seek a different order. And so, for example, it would be open to the respondent in that circumstance, site provider in that circumstance, and say, well, no, we want a new agreement, actually, because we want it crystal clear.
I mean, they might be quite happy to have the original contracting party on the hook.
Well, if your Lordships were to conclude that the consequence of the statutory continuation under paragraph 30 and a continuation under paragraph 34 rather than a renewal were to keep the original operator on the hook, which for the reasons I've given in my submission would be a surprising conclusion. But if your Lordships, because that would be retrospective and then some, but if your Lordships were to conclude that with the right analysis, they might be, in which case it's difficult to see what the actual problem is then. I mean, only for the original operator, but as I say in my submission, that problem doesn't arise because it would be remarkable if the operator was tied in not only for the original contractual term and the statutory continuation, but then one that occurred following a further order in proceedings to which they weren't a party.
I assume that you wouldn't necessarily expect the original contracting party even to be involved in the proceedings.
No, well, of course not. Well, I mean, I suspect they would say, why would we be? We left 10 years ago. So, my Lord, we say that wouldn't be right. But when one appreciates how paragraphs 33 and 34 work in practice, if that were a real concern, and again, I said at the outset yesterday, there's this deep sense of irony in certain aspects of how this case comes about. Again, if a site provider's there worrying, well, I haven't got the benefits of the agreement, well, they can, whether through their own paragraph 33 or within paragraph 33 proceedings where they're a respondent, they can seek a new agreement be imposed with the person in situ. Which again makes good my point, my Lord, that this is a temporary problem that needs to be managed, albeit I accept not a small one. If we could go to paragraph 34, but in particular subparagraph 13, this is at page 429, your Lordship had a certain amount of discussion with Learned Friend on it, I'm hoping to take it briefly. But I accept, of course, it says all the circumstances, one doesn't suggest otherwise. But in my submission, it's absolutely crystal clear that the operator's business is referring to must be the party to the code agreement who's able to ask for the new agreement or on who a notice is served. They're the party in the proceedings, they're the party who's going to be there, and they're the party who has been entitled to ask for an agreement and needs to make out, for example, what its terms should be where there's a dispute. Again, in my submission, that I should say, these cases are quite illustrative. They don't actually cause any difficulties in practice. In practice, we serve our paragraph 33 notices, and then we all go to the first tier tribunal. What tends to happen then is we have a round of preliminary issues, which are all jurisdictional challenges of various descriptions, lease license, this issue, There are usually some others. There's another one called statutory purposes that came up for a while. And we have these preliminary issue trials. And then after that, we have terms trials. And then waiting for the appeals to finish, everyone knows. And of course, what continues throughout is exactly the same parties continue in situ paying and doing everything as before. It's extremely good for lawyers. So I'm not complaining. but
the digital economy at work.
But for it's a small section of the digital economy working. But for our benefit, perhaps. So subparagraph 13 in my submission is again illustrative and indicative. The final point is paragraph 35, which is the interim provision. I don't think we particularly need to look at it, but again, the benefits of 35. The point about 35 really is this was an amendment. This came later, but or I should say parts of it came later. But the ability, for example, to seek an interim consideration, so as to bring forward that reduction in, as I said yesterday, it's effectively always going to end up, very surprising, it didn't end up being a significant reduction in
because of the
no network assumption. Yes, in paragraph 24 in particular, which is the consideration. The consideration will almost always fall, and significantly so. And it's for that reason that certain site providers are very resistant to renewals, because of course it maintains an income stream. And that's one of the...
prefer part 4 to part 5.
Well, no, my lord, well, they prefer part 4 to part 5 because that reduction in the no network assumption applies in both scenarios. That's why they prefer the 54 Act, because it's a market rent, albeit a market rent in the shadow of the code. But your lordship doesn't need to worry about that distinction. But the interim position again, so that's why pushing us into part 4. Part 4 isn't an answer; it is prejudicial because you don't get that benefit, as my learned friend rightly accepted yesterday. But B also again, it would be very odd if the interim measures were something that a party who hadn't been there for donkey's years was concerned with, but the person actually there exercising the rights and or paying the money in practice is the person who can't ask for that. Indeed, put it another way, it'd be very odd that the site provider, putting it the other way, the site provider has to ask and serve notice on a party who hasn't been on site for 10 years to say, for this interim period, we should have the right should operate in this different way, access via route B rather than route A or whatever it is. So, my lord, they are the provisions, and we say standing back, undertaking the exercise Lady Rose exhorts us to do, it's abundantly clear the party to the code agreement in the licence context is the operator in situ with the benefit exercising those rights. It's not some other party, either original party or indeed someone, as my learned friend rightly accepts, who you might have to go back up the chain to work out when was the last convergence between the two. We say that's tolerably clear from the wording, but it's especially true when one remembers the two contextual positions. One, this is about renewal. This is facilitating renewal. And secondly, when one remembers it has to work for individuals. Far easier to work out who it is you're spending the money, getting the money from and going to speak to and dealing with than someone you never heard of many years before. The general law isn't in dispute, and I won't repeat what's in our skeleton or what my learned friend said, but the point we simply make there is it doesn't provide your lordships with the answer in a strict way, because it can't mean the same thing, because then it won't work. The decision in GenCom,
So,
my lord, of course.
If I could just make sure I'm keeping up. If I go back to paragraph 31, your submission is there can only be one site provider, there can only be one site operator at any given time. So,
My lord, who is a party to the code agreement, yes.
well, that's... Well, are you reading in 31.1 a site provider and site operator as meaning the site provider for the time being?
Well, my lord, site provider can... I'm reading it together with the phrase, who is the party to the code agreement.
Because if the word site provider or site operator mean, respectively, the person who is provider or operator for the time being, I was wondering why add the words a party to a code agreement?
Well, my lord, I think for the following reason, because as my learned friend said yesterday, a number of people might be bound by the code rights. But that that is distinct from, that doesn't make them the site provider who's the party to the code agreement. We absolutely accept that. There has to be someone. I mean, another way of looking at it, although I'm very conscious, contrary to what I said to my Lord Justice Newey, I might be falling into a landlord and tenant analysis, but one also has to think about, given this is about renewal in the future, grantor and grantee, essentially, by which I mean what the parties who are most interested here and who need to be involved are, let's assume it's a renewal for a minute, because we know it could be a renewal in any case, so it must be capable of renewal. In a renewal, you are going to have, I'll use the phraseology grantor and grantee. That might be by way of license, and so strictly speaking license or licensee, or it might be by way of lease or way leave or something else. And so the two parties you want to get into the room either for the consensual discussion or indeed before the tribunal if it's to be imposed or dealt with that way, are those two parties. It's not everyone who's historically been bound, and indeed it's not, for example, operators who are merely sharers. You share the rights. That's a different thing from someone in whom the benefit of the agreement has been vested in, who is, we say, is the relevant operator. My Lord, in terms of the decision in GenCom, there are two contextual. I will take you to some passages, but I appreciate my learned friend took you through it in detail, and also conscious of our efforts today on time, so we'll see how we go. But there are two contextual points that need to be made about that decision. The first is it was dealing with leases, by which I mean the concurrent lease and the code agreement itself was a lease. So it's an entirely leasehold context. The second is that the focus is on the site provider. Of course, the reasoning addresses operator. I think the second suggests otherwise. But in fact, what the court is doing is giving a more expansive definition to site provider as a party to a code agreement in order to cater for the concurrent lease situation. And those are, in my submission, are key contextual parts of the judgment. What the judgment isn't doing, and indeed in one aspect it is expressly not doing, is considering this scenario where you have a license, and in particular a license which predates December 2017, i.e. a subsisting agreement license. The lordships in that case did not need to consider and did not consider that scenario. And so it is unsurprising that the references are littered to, for example, Part 3, or put it another way, it's unsurprising the lordships didn't engage with a distinction between lease and license, because prospectively for new code agreements, that distinction won't matter under the code, because you will have Part 3, which will achieve the same outcomes as the various statutes do for leases, in terms of benefit and burden. So their lordships weren't having to cater for, and weren't addressing their mind to, that scenario. It's notable that in his Lordship, Lord Justice Newey's judgment, in particular paragraphs 54 to 58, which is the earlier part of the judgment, that the consequences focused on, the aspects focused on, is the ability of the site provider having the right to bring the agreement to an end, under paragraph 31, as we've looked at, or both of them being able to change either by modification or renewal. There's no express discussion about the driving force or purpose or need to ensure that historically, or for a period of history, that enforcement were possible.
Sorry, say that again.
Of course not. There's no discussion by his lordship of the purpose being to ensure that at any time before you serve your notice, there's been historic enforceability of the covenant.
Yeah.
In the leasehold context, there would always be a passing of benefit and burden. That question doesn't arise where you've got lease and lease, or concurrent lease and lease. And so, as I say, his lordship didn't need to consider it, but also the law of landlord and tenant, as operated, effectively fits sufficiently neatly with the analysis. What his lordship is saying is, if under the law of landlord and tenant, as a concurrent lessee would be able to do, they would have all of the benefits and burdens, then obviously that person should be a party to a code agreement. That is, in my submission, distinct from identifying that in this scenario, which is a pre-December 2017 license arrangement, so Part 3 doesn't apply to it, that the same requirement would apply. And his lordship simply doesn't address that position at all. Of course, his lordship does refer, and I'll come back to this later, but to immateriality, which my learned friend hangs his hat on to an extent. I think he refers to it twice, both of which are quotations from the Law Commission report, that's right to say. But as we will look at, the Law Commission report expressly says at the outset of that passage, it is talking about the future. It's talking about how it's going to operate in the future for new agreements. It says that absolutely clearly. And so that's wholly unsurprising. In my submission, his lordship is not saying that in all cases it has to be immaterial. His lordship acknowledged that paragraphs 74 and 75, which my learned friend took you to yesterday, that context is key. He, of course, cites Lady Ray's judgment, I think, at 74, and then goes on to explain how he sees it working. But again, what his lordship is seeking to do in my submission, what the Court of Appeal does, is find a way of making the code work so that the site provider, who does in fact have the benefits and burdens of it, are not excluded, which is what effectively that operator had sought to do, as my learned friend outlined yesterday. And it's right to say, as my Lord Justice Lewison said in argument, as one can see from the judgment, I think at paragraph 78, that, as I accepted yesterday, no one's suggesting this all acts in a legal vacuum. The difference is when you're dealing with a lease and lease context, the law of landlord and tenant, as I say, fits very neatly with the code. When one is dealing with a post-December 2017 licence, the same can apply comfortably because Part 3 effectively mirrors the situation. That isn't true in these scenarios, but unless your lordship was persuaded we're not supposed to be able to renew, then it has to be made to work for these situations as well. And at paragraph 83, as my learned friend fairly took you to, he recognised that it wasn't obvious how that solution would work in a licensed context. Now, strictly speaking, I wasn't there, so I don't know my learned friend Mr Clark was. He may know better than me, but Mr Clark is always there, you will notice. But it may be that he knows better than me, but my reading of that is he was focused more on the situation where the code agreement is a licence and whether in fact a concurrent lessee would in fact have the benefit of that agreement, because my learned friend sought to address that yesterday by an introduction of something unheralded, again non-critical because it came out in the course of discussion, but well, maybe it would be seen to be touch and concern the land. I've certainly not seen that argument before. That would require quite an expansion of that concept in my submission. Again, that's not strictly speaking the situation your lordships have to grapple with either necessarily, because but the position is expressly not dealing with that, and in my submission even more so in circumstances where what we have is a licence that's been assigned, where we're dealing with the assignment of that licence, which is not the specific point addressed in paragraph 83 either. But what we do see from that judgment is confirmation that the assignee operator, obviously I think it was common ground, but also that the assignee operator should be able to be the party to the code agreement, albeit it's right to say that conversation was done on the basis of Part 3 in particular. It's confirmed that it has to work for leases and licenses. It's been made to work for both. Again, the distinction between those is really quite hard to see in circumstances where you're talking about a license post-December 2017. In that case, of course, his lordship adopts the answer provided by the general law. That isn't in my submission. I think both parties accept this, albeit perhaps with different emphases, an option open to your lordships on this occasion. So, in my submission, when one looks at that decision in the round, I haven't taken your lordships to it, precisely because my learned friend dwelt on it and I'm conscious of time, but I can do it, and maybe as we go through, it would be useful to you. But in my submission, what that decision does not do is require your lordships in a pre-December 2017 case to find that there has to be benefit and burden. And the other way of looking at it is the focus of the language, and indeed the language Mr Justice Fancourt particularly focused on was the phraseology of standing in the shoes of. And indeed, as your lordship said yesterday to my learned friend when looking at the explanatory note at 412, which of course is about paragraph 16 of this, really that begs the question what standing in the shoes of means in this context.
You seek to uphold the judge's decision, but you also say, well, mere benefit would be enough.
My lord.
Supposing that mere benefit were enough, how does that fit with Gen Con?
Well, my lord, what your lordship would have, it would fit in this way in my submission, which is that for the specific category of pre-December 2017 licenses, which we know are to transition through Part 5, so we know have to be accessible through paragraph 33, we've discussed, etc. In those circumstances, I say two things. Firstly, in those circumstances, it is open in my submission to your lordships to say that in searching for what standing in the shoes means, in terms of looking at the background material, it's open to your lordships to say in those circumstances it's the licensee with the benefit. The question doesn't arise about the need for burden in the leasehold context because there's no distinction. Put it another way, the second way I would put it is, in Gen Con, there was no possibility of a divorce between benefit and burden. So that possibility isn't canvassed before his lordship, their lordships, forgive me. So it's not, the Court of Appeal hasn't had to answer the question whether you have to have it, in a sense, because it was, in that case, it was obvious that would be the case. And perhaps the way I would put it is perhaps the phraseology of the difference between saying, because they have the benefit and burden, they must be a party to the code agreement, and saying in order to be a party to the code agreement, in all cases you must have benefit and burden. Because if one remembers the context, it's an operator saying to a site provider who does have the benefit and burden under the general law as a concurrent lessee, well, despite that, you're not the relevant party. And what the lordships are saying is someone who has that must be capable of being it. And so we will read it in that way, which in my submission is distinct from saying, as my learned friend seeks to say, no, in all cases you must have benefit and burden. So my lord, that is my answer to that. And as your lordship rightly says, of course, the way we've dealt with it in the skeleton is slightly more traditional. We said, well, we seek to uphold, and there's some other arguments. But as I said yesterday, the logically prior question in my submission for your lordships must be, what do you need? Do you need benefit and burden or just benefit? If it's just benefit, that's the end of the analysis. If it's benefit and burden, then of course your lordships have to examine them why. So I've dealt with this in this order, I'm dealing with this in this order because I hope it will be of assistance to your lordships because logically that's the right approach. Albeit, of course, we're very happy to uphold on the basis of Mr Justice Fancourt's decision. Turning to that question then as to whether benefits required, I mean, I've been through the provisions, so I think I can take this actually relatively shortly. But it is instructive and illustrative, if I may say, if we could just look briefly at the first tier tribunal's decision. I know my learned friend didn't, and I can see why, because on the one hand it's to some extent been superseded, but it is a specialist tribunal who has, bearing in mind the context of the practicality arguments, it is the tribunal dealing with these things on a day-to-day basis. So if we could look at that, that is in the core bundle, start, I think, tab 10. It's the decision of Judge Jackson, who the lordships may or may not know is the principal regional judge. I think that's the right title. I may have got that slightly wrong, but if I can put it this way, he's essentially the main man and the main one and deals with the vast majority of these cases. There are some other legal judges who sit as well, but in the first tier tribunal, he's the one who sees all of these at first instance. If we could start on page 121 in the core bundle, paragraph 19. Here he addresses the decision in GenCom, as we have just looked at, my lord, and repeats it. There's a couple of points we might make briefly. In paragraph 19, he notes that distinction that I've already sought to draw between licenses and the leasehold context, and also in particular the focus on paragraph 10 and paragraph 16 being available. So all of those points, it's fair to say in a characteristic fashion for the First Tier Tribunal, it's a short judgment. I wouldn't seek to criticise that, but you'll notice he packs a lot in paragraph 19. Then when he does continue, and I would encourage you afterwards to look really right through to paragraph, to paragraph 24, but in fact you will need subsequently to look through to paragraph 28 as well. I would just like to dwell, if I may, on paragraphs 23 and 24 for a moment, which is on page 123. At 23, he starts by making one of my first submissions, as we set out in the submission, or our submission set out in the Skeldon argument, is there isn't a reference to benefit and burden in the code. That's not language that comes from the code at all in this context. He says the gloss that the respondents seek to put on, that is requiring burden in this licence context, isn't required by GenCom. I obviously endorse that for the reasons I've already submitted and discussed. He makes, again, in rather truncated fashion, but the point my Lord Justice Holgate made earlier, I think, or yesterday, about the focus actually being on code rights. Obviously, the code agreements is continued, but the focus being on code rights. And then he makes his judgment that there's no requirement to read paragraph 33 in order to make it work, as saying it would only apply where an assignee, pausing there, he's talking here about an assignee of a licence pre-December 2017, that's the context, has taken all of the benefits and all of the burdens of the original contracting party. And in paragraph 24, he goes on to say that, again, trying to apply the same approach that Lord Justice Newey did, that is, as he's often asked to do, as my friend alluded to yesterday, seeking to apply the sort of rationale of Lady Rose and seeking to work out what's intended and how it's supposed to work. He says that claimants currently entitled to the benefit as assignee of the agreements are to be regarded as a party to the code agreement, with the result they can invoke paragraph 33. So he essentially accepted that benefit was sufficient in this context. And indeed, he went on to say, perhaps foreshadowing more the discussion at this court than the one below, to some extent, that would be effectively making the point I made earlier, which is when one's looking for an operator to stand in the shoes of another, that begs the question what it means. It doesn't necessarily follow what that means is being subject to all the benefits of and burdens of the original agreement under the general rule. General rule, he means the general law of contract. That's the approach he's taking. Such a construction does no violence to the words of paragraph 33, which in my submission he's correct about. So Judge Jackson, you're right, Mr Justice Fancourt disagreed with him, and I have great respect for his judgment too, as I'll come to. But Judge Jackson, which is a specialist tribunal dealing with these issues, wholly surprised to find a situation where the person entitled to the benefit of these contractual promises is saying, I don't have the benefits at all, says, well, okay, but what's the focus? What's Parliament trying to get at? How is it supposed to work? And he, in my submission, rightly concluded that was how it's supposed to work. And to a large extent, I would adopt his reasoning, albeit perhaps with a certain degree of expansion and finesse, as I've got the time to do, and the learned judge didn't have. So just to capitalise on those points briefly, as the learned judge noted at first instance, and as Mr Justice Fancourt, I think, accepts, and as everyone accepts, paragraph 30, there's nothing in paragraph 33 itself, certainly, or really elsewhere, that mandates or suggests that the focus is on the burden on the operator. Secondly, I would recall the policy argument.
Sorry, just hang on.
Forgive me, my lord, no.
Yeah.
Secondly, the policy arguments we looked at yesterday, in particular about the code being facilitative of operators and maintaining and expanding and investing in their network, but also about renewal being through Part 5. When one looks at those two policies together, in my submission, they also support that position. thirdly, the general law cannot provide the answer. Fourthly, and as Mr Justice Fancourt did accept, albeit he then felt he needed to reach a different conclusion, all of the provisions of Part 5, I think he uses the phrase strongly imply. I would perhaps in my submission go slightly stronger than that, but we would say assume that the party to the code agreement is the operator exercising the code right. And indeed, bearing in mind its context of being prospective looking, who will be exercising the code right either as modified or as renewed in the future. And then the fifth argument, which I'd just like to dwell on briefly now, is about the difficulties which arise otherwise, and that is the difficulties of fragmentation. And what I'm really doing here is comparing my learned friend's solution with this solution. So when I criticise my learned friends, I'll do that in shorthand because I will have expanded it here. But and I should say, I absolutely accept it's possible for all of us, I suspect, in this room to come up with very convoluted scenarios that law professors elsewhere would enjoy giving to their students. But I've tried to focus on realistic scenarios that mirror cases that either I have come across myself or indeed this case. So scenario 1, if we imagine we have site provider A and operator 1. This is a classic case where operator 1 transfers to operator 2 the benefit of the agreement, but no direct covenants given. On our and Judge Jackson's reading, when the contractual term date arrives, paragraph 30 continues that agreement, and it's operator 2 who remains entitled to exercise the code rights, who has the benefit. And the site provider can serve either a paragraph 31 or 32 notice on that person. And indeed, the operator 2 can serve a paragraph 33 notice. By contrast, as I've understood my learned friend's case, operator 2 does remain entitled to use the code right, but it's not either able to serve a paragraph 33 notice, nor is it to be served with, nor can the landowner, who, as I say, might be a farmer or owner of a block of flats or whatever it is, they can't serve any of the notices on that operator at all. They have to go back to operator 1, even if that's 5, 10, 15 years ago. But at any time, operator 2 can execute a unilateral deed of covenant, which, as we've discussed, they may not even need to tell the other person that they've done. And there's two consequences of that. The first is that they've made it so now the site provider is serving the wrong party, because they may well assume that they should still serve the old one, if my learned friend's right, as opposed to, in my submission, the more natural inference of it being the person in situ exercising the benefit. But also, it turns out operator 1 has just lost a right it had. I mean, I suspect a right it never thought it ever would have, but it's just lost that right. Now, my learned friend's justification for that is largely based on the idea, well, until you've agreed to be bound by the burdens, you're not in the shoes, and therefore the site provider's in a weaker position. But as I canvassed at the outset, bearing in mind my learned friend's case, it only needs to be served just before, in practical terms, maybe at the same time as serving that paragraph 33 notice. So actually the covenant, unless my lord is right and my learned friend's case adapts to being, well, it must be a retrospective one. I'll have to hear that later. But as I've understood it so far, and bearing in mind also to my Lord Justice Newey's comments, my learned friend agreed it might just be a time-limited thing. So certainly not prospective forever. It might be limited to their period of benefit. But bearing that in mind, in my submission, it's most surprising that at any time they can unilaterally do that, and that what Parliament was concerned with was effectively ensuring that during the currency of the notice you had a direct covenant. Because that is all, on my learned friend's case, you're guaranteed to have. You may have it earlier. The direct deed of covenant may be put in its drawer or indeed served on someone 10 years before. But it may not be. It may be done just the day before or the minute before you serve the notice. If we take scenario 2 then, so that's the same, except operator 2 does this time give its direct covenant, but operator 3, to whom it then subsequently assigns the benefit, doesn't. Again, on Tower's case, in respect of only needing benefit, on Judge Jackson's analysis, it's the same outcome as scenario 1. It's relatively straightforward. You look at who's the operator with the benefit in situ, exercise the code right. That's the person we serve the notices of. By contrast, on my learned friend's analysis, it's now operator 2 who can serve, because although operator 2 no longer has the benefit, because it's assigned that, it's the last person who had benefit and burden, because it did give a direct covenant. Even if, as my lord discussed, even if that is a direct covenant that was time limited, no longer applies. So in fact, as I understand my learned friend's case, operator 2 is now the person on whom notices need to be served, and who has the right to serve a notice, even though it no longer has benefit or burden. Because it was the last person to have benefit and burden. And in my submission, that plainly can't be right. A third scenario is the same as scenario 1. So we've got our site provider A, operator 1 assigns to operator 2, but in this case, site operator 2 does give a direct covenant, but to site provider A, and then site provider A assigns to site provider B. Now, on our case, again, it's pretty straightforward. Site provider B can serve the notice, and it can serve the notice in operator 2, and there's no difficulty with that. But we don't have here a direct covenant given by operator B to site provider B. Now, it is possible, of course, as my learned friend suggested, that the deed of covenant might be given sufficiently expansively to be capable of assignment, or it might not. Bearing in mind, especially as my Lord Justice Holgate posited yesterday, that we're often working on the assumption that site provider is either a freeholder or a lessee, but it could itself be the licensor. And we know that because we know that someone at the outset may be a mere licensor, but they may be the occupier from whom an agreement can be given or needs to be sought. So in those circumstances, we say that also it doesn't work as an analysis. And again, standing back, your lordships can't be satisfied that Parliament intended this scenario to be what Parliament wished to work for individuals as well as sophisticated parties. So, my lord, looking at those, we say that another way of putting it is that with pre-2017 licenses, you can't have a pure standing in the shoes of, as my learned friend's case seeks to suggest. And he rightly, I think fairly conceded, Mr Justice Fancourt recognised this as well, albeit he said it didn't necessarily matter, that because you can't have that as a matter of the general law, we know you're then looking at something else. So obviously if a direct covenant is given, then it's actually a breach of that covenant. It's not a breach of the code agreement, for example. And the same, you can't actually be a benefit. But in my submission, what's surprising about my learned friend's solution, as Mr Justice Fancourt rightly noted, is it is extremely restrictive. There is reference, my learned friend sought yesterday to slightly distance himself from that position and say, well, I'm using it as a shorthand, there may be other ways. Three bouts later, I still don't know what those other ways might be. Mr Justice Fancourt spoke about the possibility of something arising out of the conduct of the parties, but that sounded more akin to an estoppel, and that's a different question. It may well be that someone is stopped from denying that they haven't given a deed of covenant or that they're not the party to the code.
You get into all those difficulties of formality requirements and whether you can opt out.
My lord, precisely. And so then you get, and you also get into difficulties about whether one can stop oneself in or out of a statutory scheme. The reason I know that is because my learned friend, Mr Watkins, so eloquently put that argument when resisting an estoppel argument not very long ago. I say resisting, the learned judge, it was a different context, but the learned judge didn't decide the point, I should note, if we're scorekeeping. But the point, my lords, is simply this. That's actually rather begs the question. It doesn't help, because also the point about an estoppel, as your lordship anticipates, is about getting around what you haven't got. It's about that can't, you may be estopped in or out. That's a different question. Parliament didn't, we say, sit there and say, well, one of the things you can do is be estopped into this, and the other thing you can do is give a direct covenant. So it is, in fact, is incredibly restrictive, and my lord, Mr Justice Fancourt, was right to identify it as such. Can we look just briefly at the Law Commission report? If we could look at, it says Authority Bundle 2, tab 19. And if we could start, if we could look at page 488, please, and starting at paragraph 316. My learned friend took you to this section, and indeed this is section is what's referred to in my Lord Justice Newey's decision in Jancom. I just note in paragraph 316, at the second sentence, it says, in what follows we refer only to agreements entered into and code rights created after the introduction of the revised code. And in my submission, it would be rather dangerous, and is rather dangerous, and to the extent it's happened, it's a mistake, to place too much emphasis in asking how it's supposed to work for other types of agreements. The context here has to be remembered. The driving force behind these amendments, which become part 3, as my learned friend showed you yesterday, in terms of the recommendations, that's what effectively becomes paragraph 16 and onwards, is Parliament seeking to overwrite the general, both the general law, but also the sometimes contractual position, which doesn't apply in this case, where there were restrictions. And so the Law Commission is looking at justifying, should we be doing this? If so, how should we be doing it? And in overwriting the parties' contractual positions, the Law Commission is identifying that one of its recommendations would be that the burden provision would be made for the burden to pass, and indeed that becomes 16.4. And as we see 16.5, one of the other recommendations is, again, mirroring the law of landlord and tenant to some extent under the 1995 Act, not for old leases, but for new leases, being a situation where liability can be removed. And as your lordship said yesterday to a learned friend, there may be a period of time where there's two people who are liable, if it happens certainly during the contractual term, but then once notice is given, that liability is alleviated. So the Law Commission is focused here expressly, prospectively. How is this going to... We're going to impose this on people in the future. We're going to prevent them. We're going to interfere with their otherwise freedom to contract for restrictions. How is that supposed to operate? And as you will see when your lordships go back to Lady Rose's description of the code generally, each of the different parts, of course, I absolutely accept the code is read together, I'm not suggesting to the contrary, but each of the different parts are to some extent self-contained in terms of how we see that at the beginning of each, this is what we're doing here, this is how it operates, and the language changes in some places as well. In terms of how it is used, particularly with regards to keeping the situation of site providers. So in my submission, one has to be very careful when reading, as the Court of Appeal did in Gencom, and as my learned friend seeks to do here, the Law Commission report talking about, and I would say it's not an absolute immateriality either, it says generally material. My learned friend presents it perhaps as an absolutist rule, it's not. But when looking at general immateriality, etc., the context is prospective only. It is not a consideration as to how it's supposed to operate for this category of agreements. Again, coming back to my point that this is a temporary, albeit important problem. And so in my submission, when one looks at that, one cannot take from that. And I should also add, I think this point only goes so far, but I'll make it. There's no draft bill What this can help us with is at most general mischief about particular aspects, but the mischief it's looking at here is how assignments are to work in a context, in a world where you cannot prohibit assignments anymore. It's not looking backwards and saying how has that worked in the past and how should that transition, because the assumption inbuilt, there's no express discussion of how that should be at all, but the assumption inbuilt, what is clear, as we discussed earlier yesterday, my lords, is about how that's the transition is supposed to be through part 5. So, my lords, for those reasons, in my submission, there is nothing, not only is there nothing preventing your lordships from concluding that benefits is sufficient, as Judge Jackson did at first instance, but that is indeed, in my submission, respectfully mandated by the provisions and the policy of the Code. If I'm wrong about that, or your lord, in any respect, then the question is how that burden is to be satisfied. There are 4 solutions that have been presented before you. The first is APW's case, which is essentially there must be a direct covenant given. I will address some aspects of that now briefly, but obviously I've already taken you through the scenarios, and that all is to be, stands good and is to be repeated. The second is his lordship, Mr Justice Fancourt's solution, which I'll also aim to discuss. The third is paragraph 12, which my learned junior Ms Briggs will address your lordships on. At the risk of yo-yoing, to keep logical order, I will ask her to address that before I then return to address benefit and burden. But if that offends your lordships, I'm quite happy to switch it round, but that would be my preference. Although, as my learned friend says, the benefit and burden principle, what we're not seeking to do is revisit the law of contract and rewrite it all. It's a focused argument, which is quite contained. Turning to APW's solution then, which in my submission does amount to saying you have to give a direct covenant and nothing else will do. It's difficult to see what that would be. I think there was, I can't remember if there was some discussion or if I simply wrote myself a note about the possibility of something being done orally. That in my submission would be even more surprising given the alleged need for certainty. Because we all know, we all make fine livings or have historically made fine livings from people thinking they've agreed something and then not done so. So that would be most surprising. The difficulties for my learned friend are firstly the wording in the provisions, in particular paragraphs 30, 31, 32, 33, and 34, 13, how they're supposed to operate. Especially in a context where my learned friend's provision is requiring a purpose of approach as well. My learned friend is not taking a literal approach and holding that up against. It is, as I understand it, effectively conceded. One can't do that because the law of contract, as we say, wouldn't make these parties to a trade agreement anyway. And those difficulties have been illustrated in my submission amply by the discussion of those 3 scenarios, but also with the twists, or the additional twists that I've taken in part from your lordship's questions yesterday about time-limited covenants, etc. as well. There is the risk, as also dealt with in the scenarios, of fragmentation. Now, that is a criticism that below my learned friend held up against, in fact, benefit. He said, well, you're divorcing benefit from burden. And in one sense, I accept, I mean, we of course say we are bound for other reasons, but we accept that if that were the right answer, of course, I should say, if you only need the benefit, that doesn't mean the burden hasn't passed. Our argument on paragraph 12 still applies. It's simply that it becomes an irrelevant question for your lordships, because this isn't an enforcement case. This is a case about whether we have the statutory right to serve the notice or not. But fragmentation is, in fact, in my submission, a problem for my learned friend's solution. And as we will see when I discuss Mr Justice Fancourt, I, of course, accept that some of the criticisms I make on my learned friend's position must be capable of being made of Mr Justice Fancourt's position. They both lack the benefits, I would say, of Judge Jackson's analysis and of my primary submissions, as it were. However, I would say his position results in a far worse situation for a number of reasons. One of which is, as his lordship identified in judgment, what happens as a matter of practice. There is, one can see from the agreement, and my learned friend referred to one deed of assignment yesterday. I think it was that one. No criticism of him. It's quite difficult when we're all looking at different documents to know if we're looking at the same one or not. There was a page missing, in fact, from the bundles, so no, I noticed.
We've never had it.
No, I don't think we necessarily have it either. We don't have But there is a page missing from one of the agreements. So absolutely, except we haven't shown what was or wasn't in that. But it's a more historic deed of assignment, and of course, no one's relying on a chain either way, so that doesn't really matter. But the point I'd make is, it is clear that there is, as indeed was the case for both of these and other sites, that indemnity being given is something that happens in practice, and is standard conveyancing practice indeed. Both generally, but also in particular in respect of these assignments of code agreements. By contrast, it is not standard practice to give a direct deed of covenant unless the contract requires it. And in particular, unless the contract requires it as a precondition for assignment. So Mr Justice Fancourt was right in my submission to say that his solution, as it were, would be to be preferred because it would not be as restrictive. Because the other thing to bear in mind is, my own friend again will say, well, what's the harm? We can just give a deed of covenant now. But of course, we're not just dealing with the sites, we're also dealing with sites where notices have been served, which is not limited to these two sites. It is in this case, but it's not limited. Plenty of, and indeed it is quite common, indeed, it's been the subject of other litigation. Quite often notices are served and then there's no time limit for them making your application. So it doesn't work like the 54 Act, where you make a paragraph 30, you give a section 24 notice, and then you've got a date by which you must apply, unless you agree on extension. So there is no time limit. So there are hundreds of notices at the very least, if not more, by multiple operators out there, operative. And on my learner's friend's case, they're all rendered invalid. So it isn't as straightforward as saying, well, you can just simply do that. All of those people would have to start again, including where proceedings indeed are on foot. My learned friend relies on clarity, but as we've demonstrated, I think, through the scenarios, in some cases that may be very straightforward because it will have you served a direct deed of covenant or not. But let's think for a second about the site provider who wants to serve a notice under paragraph 31. He or she might know that they've not received or think they've not received a direct covenant from this person, but A, if they're an assignee site provider, that doesn't tell them anything, because then they don't know necessarily what their predecessor has or hasn't received. And B, and indeed, they also don't then know, or they then have the difficulty of trying to chart back and work out if there was a convergence of benefit and burden at a particular time, and if so, who that was. And if I can say, and where that person is now. I mean, there'll almost certainly be a company. So, does that company still exist? What's it called? Where's it now located, etc.? I've got no relationship with this person, but I now have to go on. We say that is not the same. And vis-a-vis Mr Justice Fancourt's solution, the difference there, although it doesn't have to be in the same document, as you have seen in this case, is when the party with the benefit of the code agreement says, I've got the benefit of the code agreement, and wants to prove title, if they're put to that proof. Most cases, of course, they're not. It's only in these sorts of cases where that happens. But where that happens, of course, in those circumstances, it's almost always in the same document. Here it is. Not this need to conduct a historic search of not only of transfers assignments of benefit, but also of a need to conduct a search as to the transfer of the burden, which may well be, in fact, on my learned friend's case, should be, or will be, in practice, a series of independent deeds. And you will need to look at others necessarily, because unless the last person has it, you've got to work out who your person is. As I say, it's not just about receiving the notice, it's also about the ability to give a 31 or 33 notice. I repeat the point that, to the extent my learned friends are seeking to suggest that Parliament's concern is to ensure enforceability, that is, in my submission, it would be a surprising way to do it if, as I have postulated, and unless my learned friend now seeks to adopt my Lord Justice Foxton's possibility, that somehow it has to be a retrospective deed of covenant saying, well, I'll cover all of that historically, then in fact it could be validly given only for the currency of the notice. I mean, you wouldn't express it like that, but that would be the effect.
Still face your operator 2, operator 3.
Yes.
Presumably operator 2's deed was not forward-looking, even if if it was backward looking.
My lord, yes, you're absolutely, my lord's right, absolutely. So you may have a scenario where, for the relevant period, there is no burden. My lord's precisely right. And the justification in terms of standing in the shoes, and this is maybe the heart of the distinction between my learned friend and Mr Justice Fancourt's solutions, is this. If you do have to stand in the shoes, on whom is the focus? Mr Justice Fancourt's focus, in my submission rightly, and in accordance with, for example, paragraph 30 of the code as we looked at earlier, would be on, if you have to have burden, have you assumed responsibility of the burden? Have you accepted that you have the burden? Have you accepted that you get the good and the bad, as it were? Or the plum and the duff, however you want to put it. As opposed to whom do you owe that? My learned friend's solution and arguments bake in an assumption that the concern is to ensure that the site provider, pausing there in parenthesis, or at least a historic site provider, possibly not the current one, but some site provider, that they have the benefit of that burden, as it were, that they have the ability to enforce against you. That isn't found anywhere in the code. And what, in my submission, Mr Justice Fancourt was doing was recognising that if he had to look for burden, what he ought to be concerned about was a situation where a party was effectively not just taking the burden and being unwilling to undertake the benefit, being unwilling to take a burden, a willingness to take the burden, but that what the code isn't concerned with and what Parliament wasn't concerned with was a situation of making sure that burden was owed directly to a particular site provider. As I say, looking at the scenarios, it's not even necessarily to the site provider who would be the party to the code agreement at that point. And so, I should say on that, unless my learned friend's position is the current site provider would never be the site provider to the code agreement, and it's always the old site provider. He could say that. He could say, well, no, if you haven't got the benefit of a covenant, maybe you don't have the benefit of the agreement. Of course, that can't be right. You've got the benefit of the agreement anyway, because that's been assigned to you on this hypothesis, but you won't necessarily have the benefit of the direct covenant. So, my lords, that is in my submission, in many respects, why Mr Justice Fancourt's solution is the appropriate one. And if we could look briefly at the judgment, so if we could go to the core bundle, tab 6, starting at page 103. In fact, if we could pause on page 93, actually, my lords, that would be helpful. At paragraph 38, I think my learned friend took you to this, it's at the bottom of the page. This is where his lordship accepts effectively the submissions I made earlier about the operation of part 5, and how that's intended to operate. I say he uses the phrase strongly implies, but in my submission, one can go a little further. And indeed, one sees over the page into paragraph 39 as well. Where he accepts the need to have relative clarity. Where I part company with my lord is the suggestion where he says, well, if you only have to show benefit, that doesn't assist with clarity. In my submission, that's not right. It's a far simpler exercise to undertake, and it gives no doubt. Indeed, he gave, in this case, is illustrative of that. Now the parties in any doubt as to who's got the benefit of the agreement, relatively straightforward. What burden you have to show and whether you've shown it or not, significantly more complicated, seemingly. If we could then go to page 103, when the lordships are ready.
Where, sorry?
103.
Thank you.
Call bundle stuff. We note at paragraph 89 his lordship's conclusion, which I endorse, that it's too prescriptive. My learned friend's conclusion is too prescriptive and restrictive. He explores some of the same reasons that I've discussed, and I, of course, would commend paragraphs 89 to 91 to your lordship's attention. And then if we could move to paragraph 92, this is where his lordship praises his lordship's solution. And this is where, as your lordships will be aware, the focus is on the assumption of primary responsibility. And what his lordship is doing is seeking to make the code work, quite frankly. That's what his lordship is endeavouring to do. But having concluded, in my submission wrongly, that he needed to find burden, what his lordship is then doing is trying to make that as expansive as possible, much in the same way, I should note, as the expansive nature of what Lord Justice Newey was trying to do in the Court of Appeal in a different site provider context. And what he does there is not restrict it to any one particular type of assumption of the burden, but it's effectively any assumption of the primary responsibility. In this case, that includes indemnities, and that's the relevant provisions as he's so found. I don't think that's things accepted. If his lordship's right on that, then these cases remain decided as they were. But obviously, he doesn't rule out other possibilities. I mean, one was the multi-part did. One assumes if one had that, there wouldn't be much dispute. So maybe that's wishful thinking on his lordship's part. But he recognises that's a possibility. He recognises the giving of a covenant might be a possibility. He's not ruling APW's position out. He's saying you simply can't read the code and interpret the code as saying that's the way of doing it. And if one is accepting that it doesn't have to be an obligation to the other party, because that's the gloss my learned friend assumes. And then in those circumstances, his lordship's conclusion works. What it does is it gives the parties, if you need the burden, the greatest possible chance of mirroring what is of getting to the position and mirroring the position that Part 5 assumes, by reference, in particular, to the practical realities of what the parties do. It is absolutely wrong to suggest that this is in any way particularly burdensome, as my learned friend does, or unworkable. Indeed, it works perfectly well. An illustration of that is there is a batch of sites which we had another preliminary issue trial on earlier, where my learned friend rightly reserved his position on this and said this issue is raised. But where there's, I can't remember the exact number, 4 or 5 sites where it's identified. Well, if Mr Justice Fancourt is wrong, you need direct covenant, there's no direct covenant. But if he's right, here they are. It's perfectly workable as a solution, and is preferable in my submission because it rightly, focuses, as a matter of principle, on the assumption of responsibility. It's not about to whom, firstly. And secondly, because it is expansive, and so facilitating the moving over of as many of those license agreements that are telecommunications agreements as possible through Part 5 in as untroubled a way as possible. The problem then disappears, because once you use the phrase transition, once you transition through, there'll then be a new code agreement to which Part 3 will apply if it continues as a license, or if it becomes a lease. Part 3 will continue to apply anyway, but the issue wouldn't arise anyway. So for those reasons, in my submission, Mr Justice Fancourt's solution works. Another criticism of my learned friends, I should say, or another response to one of his arguments, which he, in my submission, made more forcefully below, but did repeat here, is about the availability of Part 4. My learned friend says, well, if it doesn't work, you've got Part 4 anyway. That's always a possibility. Respectfully, that's not right. It's not. Part 4 is not available necessarily, but it's not right that can be Parliament's intention for this reason. Firstly, because, as my learned friend rightly accepted, there are prejudices. I'd use the word significant prejudices. He wouldn't, no doubt, but there are prejudices on any view between Part 5 and Part 4. The most obvious is the interim position. And just to bear in mind, your lordships may sit there and say, well, how difficult can that be? How long does that matter? In the case of Queen's Oak Farm, I think we're coming up to the 6th anniversary of the reference. Now, that admittedly is a case that obviously went to the Supreme Court and then went back, but we are, in fact, due for an appeal second time around in the Upper Tribunal next month. So that's still going on. Admittedly, they don't all take 6 years, but there are, as I said, preliminary issue trials, terms trials, etc. So it is a significant difference whether one is able to seek to rely on an interim consideration to reduce that burden in the interim, or indeed if other rights are needed or need to be. So that's the first thing. Secondly, my learned friend referred to the fact that, one could serve a paragraph 31 notice. That is correct. A paragraph 31 notice can be served. I should say they're not always served. This is a case indeed where one wasn't served, but and so there will be cases where site providers don't serve paragraph 31 notices, and so then the operator is needing to address and engage with the imposition test. Now, I'm delighted to hear my learned friend say that's a low bar and it should be very easy, because I am yet to see myself not being put to proof on any of those cases where we do go under Part 4, and when that issue is conceded is often quite last minute in the day, but nonetheless, it is good to hear. I agree it's a relatively low bar, but nonetheless it is a hurdle one has to go through. One doesn't have to go through under Part 5, because one is asking a different situation. And it's also clear as a matter of principle that can't be what was intended, because we know from Compton Beecham, if I just give your lordships the paragraph reference, I'll find you the page reference in a minute if I make that. My note fails to make provision for it, but it's paragraphs 115 and then 127 to 128 of her ladyship's judgment.
Right, 115 and then
127 to 128, my lord. And that confirms that there is a distinction between Part 5 and Part 4. And what Part 4 is supposed to do is get you new rights. And the difficulty here is, which might be a midterm right, as my learned friend rightly identified, and as her ladyship recognises, or might be where you don't have the benefit of a code agreement. But Part 5 is what you're supposed to do if you've got the benefit of a code agreement. And there's no dispute here that my client as the assignee has the benefit of the code agreement. That's accepted. And so in my submission it would be surprising if whether you use Part 4 or Part 5, if the parliamentary intention as to which of those routes is open to you is dependent upon, I of course say burden at all, and I've made that submission earlier, but if you do need burden, it'd be surprising if you had to do that dependent upon whether you go through the hurdle of giving a direct covenant, which isn't mentioned anywhere. Whereas at least Mr Justice Fancourt's approach to that is simply to look at, if you do need burden, have you assumed the responsibility for burden? In my submission, as a matter of principle, that is the correct analysis. The other distinction, and this is the point I alluded to yesterday, I think, at the end of the day when talking about retrospectivity, and we've touched on that today, again in a different context, but there are agreements historically which required as a precondition, or there could have been agreements, I think there probably were some, which is a precondition for assignment, you have to give a direct deed of covenant. One does see that from time to time. If the parties haven't negotiated for that prior step as a precondition, then that is, on my learned friend's case, a precondition that is being inserted. Now, my learned friend might say, well, to some extent you can make the same criticism of Mr Justice Fancourt's, because there may not be a clause saying you have to give an indemnity. But the point about Mr Justice Fancourt, as I say, is he's not looking at vis-a-vis the parties. He's simply saying, has the operator assumed responsibility? Whereas on my learned friend's case, the site provider is better off than they otherwise would have been insofar as they're entitled, including during the term. You only become a party to the code agreement during the term if you are giving a direct covenant. And so in my submission, in fact, what my learned friend does is, very clearly in my submission, what he does is seek to improve the bargaining position retrospectively. And so it in fact breaches that policy at aim 2. Turning to some of the criticisms that are made by my learned friend.
Handwriting may be causing some.
My learned junior is not the first and clever enough for that, so yes. Can I just turn around briefly just to check something? My learned junior is sufficiently industrious, she got there in the end. So let me just turn then to some of the issues that my learned friends raised. Immateriality, my learned friend addressed, and that's a prime thrust of his criticism. To some extent, I've already addressed that. That, as I say, is even when I say a borrowed concept, I think it would be to imbue it with too high a station as to suggest that's the basis for Lord Justice Newey's decision. It's right to say two parts of the standing in the shoes is certainly part of it, but what that means in different contexts is, as I say, open to interpretation. But what is clear is that those phrases come from the Law Commission report, which, as I've already outlined to you, is concerned prospectively only. It's concerned with the position moving forward. It doesn't talk about this particular category of agreement. I've also noted to your lordships already, it's not an absolutist requirement. Malin, I might suggest perhaps more in writing than orally, sort of presented it as a strict and definitive test. In my submission, it's not that. Even by the Law Commission standard, that's not what they're looking at. Their justification for why is, well, it shouldn't really matter in practice. And that is one of the reasons why they can exclude the possibility of seeking to ransom. And it's notable from the Law Commission provisions that, or discussion, that one of the particular things they're focused on is preventing site providers from extracting ransom value upon those assignments, or indeed upon sharing. Your lordships may be aware, but historically there used to be what was called pay-away. And of course that still exists in some of these older agreements. Pay-away was getting a percentage of the licence fees paid by the MNOs to the whip, for example. So if I'm the whip who's got the benefit of code agreement and I share, it might be 20, 30, 40%, whatever it is I have to pay across as well. You can't have that in new agreements. Another reason why renewals are so unattractive for some site providers. But that is a key focus, as you will see when you read in more detail the Law Commission's report as to what they're doing, and justifying stripping out, again, the immateriality is justifying stripping out that ability and value, rather than it being the starting point for requirements in the way my learned friend ceases to use it. I don't propose to take your lordships to the explanatory 412. Again, more was made of this in writing than it was orally, but it simply begs the question. It doesn't, I don't think my learned friend's meant to. There was, on one reading of the skeleton, it might have suggested it said immateriality within it. I don't think that is what they meant to say, and it doesn't. It speaks of standing in the shoes. But of course, what's the context of that explanatory note? It is explaining paragraph 16 and how it operates, which doesn't have any application here. In respect of standing in the shoes, as I say, that's the second thrust of my learned friend's criticism of Mr Justice Fancourt is, well, you're not standing in the shoes. But as I say, what the difference between my learned friend and Mr Justice Fancourt is they are looking at from the question as to whom the obligation is owed. They're not standing in the shoes vis-a-vis the site provider insofar as, if there's no direct covenant, enforceability. To some extent, that must be correct. But I would encourage this court to take the same view as Mr Justice Fancourt did, which was on the assignee. The focus is on the assignee. Is the assignee willing to take burden? Not, is the assignee willing to take the burden to the site provider? That's a gloss or assumption my learned friend makes, which in my submission has no justification in the code. This isn't a case about the mechanics of enforcement. This isn't an enforcement case. And as I said at the outset, it's notable and somewhat ironic that this isn't a case where enforcement would even arise as a question. Mr Justice Fancourt's focus is instead on enabling assigning operators who are in situ with the benefit to be able to serve and receive notices. He's trying to get to the same position, just addressing the question of burden and finding in my submission a practical way, or a more practical way of doing so. I would accept that to the extent one is seeking needs burden, if your lordships accept one needs burden, and your lordships are against us on paragraph 12 as an answer, or indeed, depending on how widely it's applied, the benefit and burden principle, then neither Mr Justice Fancourt's solution nor my learned friend's solutions are perfect. They are both imperfect. I think my learned friend accepts that too. Where we differ is my learned friend says, well, Mr Justice Fancourt, worst of all worlds, and we say that that's simply not the case. And it's not the case really from the site provider's perspective either, because as I say, in practice, this isn't about enforcement. This is simply presenting a hurdle to defeat historic notices in cases where there's been no difficulty of enforcement historically, and this is one of those cases. And then in terms of certainty, in my submission, as I've already addressed to some extent, that is a ill-founded criticism of my Lord's solution. To put my learned friend's case at its highest, they both require similar exercises. Mr Justice Fancourt's solution may be open, at worst from my perspective, may be open to the same or similar criticisms. In my submission, for the reasons I've given, in practice, actually, it's more likely to lead to certainty for the reasons he gives, his lordship gives, but also because as a matter of practice, as his lordship recognises, that is, in practice, these are given, and indeed they're usually given in the same documents. And so it's far easier, as in this case or these two cases demonstrate, it's far easier to be able to identify that than possibly having to go through a series of historic transactions and indeed potentially parallel transactions where we have assignments of benefit and then deeds of covenant given at different times. The final criticism is paragraph 31, or the final substantive criticism in writing was paragraph 31, and about those termination provisions. I've already addressed your lordships on that. One point I would just make is perhaps the example of a repairing covenant, because if the relevant party in paragraph 31(4) is the original operator, the original operator isn't going to be in a position anymore, not having the benefit of the agreement or indeed access to the site or not having been there for a decade, potentially to perform any of those covenants. So again, it's a slightly strange position to require that solution. And in my submission, that is a criticism that doesn't land against Mr Justice Fancourt any greater than it would land against my learned friend's solution. So for those reasons in my submission, if your lordships do conclude that contrary to my earlier submissions, burden is required, then out of the, I say, for reasons my learned junior is going to articulate, we say paragraph 12 does the magic, and if it doesn't, I will finish later with another possible solution that would also be sufficient for the burdens to have passed. I'd say the irony here is we accept our position is they have passed. But to the extent that your lordships feel neither of those work, then as between the two, we would encourage you, we would say Mr Justice Fancourt's decision then is unassailable. On the assumption that burden is required, his solution is far more workable than my learned friend's. And especially when one holds that up against the policy aims of the code. It is far more facilitative in practice and in principle to achieve that outcome than my learned friends. The only thing it doesn't achieve is direct enforceability. And quite frankly, historic direct enforceability, or very limited period of time direct enforceability, that my learned friend's solution would achieve. But there's no indication in my submission that is what the code is focused on, and that is especially true when one considers the context of it being about renewals and about maintaining the status quo, but getting you transitioned into the new agreements. So, my lords, they conclude those submissions. If I could just take 1 minute to pass the lectern back. My learned junior, Ms Briggs, will be addressing you on paragraph 12. And then, as I say, I'm sure she'll take to beyond lunch, and after lunch I'll deal with that. Just on timing, my lord.
It's looking quite good, isn't it?
It's fair weather. We will undoubtedly be done today. I'm optimistic my learned friend will have a sufficient period of time to deal with a reply, bearing in mind he's already got his supplementary discovered arguments as well. But obviously we can see where we are in half an hour.
Yes.
Thank you. Good afternoon, my lords. As you would have gleaned from our skeleton argument and from my learned friend Mr Watkins' submissions yesterday, it's On Tower's position that if and insofar as GenCom requires an operator to be bound by the burden of a code agreement in order to qualify as the party to that agreement, then any such burden will have passed by paragraph 12(1) of the code. That is what we mean when we say, as a shorthand in our skeleton, that code rights are statutorily imprinted with the terms of the agreement. At first instance, this argument was accepted by the first tier tribunal, which, as Mr Lees has emphasised earlier, is of course a specialist tribunal. My learned friend Mr Watkin has already taken you to the relevant sections of the judgments of my Lords Mr Justice Fancourt and Mr Justice Edwin Johnson, and he has also explained what APW says paragraph 12.1 does, and so to a certain extent I can take those points relatively shortly. Mr Lees and Mr Watkin each had 6 propositions for you yesterday. You may be pleased to hear that I only have 4. In summary, it's On Tower's position that, first, paragraph 12.1 is not concerned with statutory immunity, nor does it have a merely clarificatory effect, to borrow my learned friend Mr Watkin's terminology. Rather, and on a proper reading, what paragraph 12.1 does is it provides that if an operator is desirous of exercising code rights, then they must, as the quid pro quo, accept the burden of the code agreement conferring those rights. That is its effect. We say that that is the natural and ordinary reading of paragraph 12.1. If you're not with me on that, my lords, then that takes me to my second proposition, which is that without prejudice to what I've just said, even if that isn't the ordinary and natural meaning, then we ought to read the code purposefully in order to achieve that result. My third proposition is that
Hang on, sorry.
Apologies, of course. My third proposition is that On Tower's interpretation renders paragraph 16.4 of the code neither redundant nor otiose. I will come on to explain in the course of my submissions that paragraph 16.4 forms part of a self-contained statutory scheme Mr Lees has already addressed you on. It's a regime which confers upon operators automatically and irrespective of the bargain that the parties have actually struck, and irrespective in particular of what their alienation provisions say, the right to assign, and makes provision for the assignor operator to drop out of the picture, as it were. Those provisions, we say, are concerned with making the assignee liable in place of the assignor, not liable per se. My fourth and final proposition, my lords, is that none of that is called into question by the Law Commission's report, to which Mr Lees has already taken you. Relating back to what I've just said, it's On Tower's position that the concern of the Law Commission in that report was one, prospective, but two, was making assignees liable in place of assignors, not just generally. My lords, in establishing those 4 propositions, I intend to adopt the following structure. I'm conscious that my learned friend Mr Watkin took you there yesterday, but I propose to start with the wording of paragraph 12 itself and just look at the wording that was actually employed by Parliament. Secondly, I propose to address you on the reasons why we say paragraph 12 ought to be construed in the manner for which we contend. And then finally, I intend to address some of the criticisms that have been levelled at On Tower's analysis by APW, with particular reference to the judgments of my Lords Mr Justice Fancourt and Mr Justice Edward Johnson, and explain why none of those criticisms undermine On Tower's analysis as to the effect of paragraph 12.1. So, turning then to its wording, it's found in part 2 of the code, and to make an obvious point at the outset, it applies with equal force to subsisting agreements, such as the type under consideration here, and also new code agreements, so it's of general scope and application. Could I please ask you, my lords, to turn up page 388 of the authorities bundle, and for those of you working from paper, that's bundle 2, tab 14.
Is this for paragraph 12?
Yes.
I say that because I've
It's very
printed
short.
it out in a different form.
Of course. Subparagraph 1 is a very short paragraph, and it reads, a code right is exercisable only in accordance with the terms subject to which it is conferred. I'll come back to the proper meaning of that in just a moment, but for present purposes there are 2 points that I would wish to note. The first of those is that the wording of paragraph 12(1) presupposes the existence of terms generally.
Sorry, can you say that again? It presupposes...
The existence of terms. And I say that as a general matter, because secondly, it presupposes the existence of terms plural. It's On Tower's submission that that is significant, and the reason for that is that typically, in the ordinary course of things, as one would expect, a code agreement will contain terms which are burdensome for an operator. That might be the payment of rent in a leasehold situation or a licence fee. However, it need not do so. There is no such requirement in the code itself. In order to qualify as a code agreement, then an agreement need only comply with paragraph 11 of the code. From memory, my learned friend took you to paragraph 11 yesterday, and so I don't propose to take you there now, but for the purposes of your note, my lord, it's at page 387 of the authority bundle, which will also be bundle 2, tab 14. For present purposes, it's important to note that paragraph 11 does not say that a code agreement must be for value, nor does it say that an operator must owe obligations to the site provider, such as the type of obligations that my learned friend Mr Watkin canvassed yesterday, an obligation to maintain a stock-proof fence. So it's perfectly possible for a code agreement to be entirely beneficial for an operator. There's simply no need for it to be subject to any terms, if that phrase is understood to mean terms and conditions, as opposed to the terms of the agreement. Despite that...
Is that a realistic possibility?
We say it's a possibility. We say that on the ordinary meaning and the language as we have it before us, before we get to a purposive interpretation, it's at least one possible reading of those words, my lord. And to bolster that submission, my lord, we say that paragraph 12 could have said, for example, a code right is exercisable only in accordance with any terms subject to which it is conferred. That would have been an alternative writing of that paragraph that would have recognised that it's not necessarily going to be subject to any terms. And that's why we say, properly understood, or at least the starting point, my lord, the reference to the terms must be a reference to the terms of the code agreement. Yesterday, my learned friend sought to dismiss that as being mere semantics. Mr Watkins sought to place reliance on paragraph 11(1)(c), which stipulates that the code agreement must specify the duration for which a code right can be exercised. Mr Watkin argued that a code agreement, because it must be limited in its duration, there is at least one term restricting the exercise of those code rights. Our response to that, my lords, is that that submission ignores paragraph 30 of the code. We looked at this provision in some detail yesterday, and we've looked at it again this morning. So I don't propose to take you there now. For your note, and we're still bundle 2, tab 14, that's page 420 of the authority bundle. As we've seen, the effect of paragraph 30 is to provide for the statutory continuation of code agreements after their contractual expiry. So even in the context of an entirely beneficial code agreement, it makes no sense to say that paragraph 12(1) is clarifying that the code right can only be exercised for however long that agreement says, because that would cut across the effect of paragraph 30, which is to continue it thereafter regardless. So, stepping back, we say that as a matter of language, paragraph 12(1) is directed towards the terms of the code agreement, not any terms and conditions that may or may not exist. In our submission, this interpretation has the benefit of imbuing paragraph 12(1) with some meaning and substantive effect. In On Tower's submission, paragraph 12(1) must be aimed at doing something more than merely stating the obvious fact that a person exercising a code right must comply with any conditions attached to its exercise. We say that goes without saying. So, to borrow an example from our skeleton argument, if the code agreement says that an operator can only lop trees, which was one of the code rights enumerated in paragraph 3, between the hours of 9 a.m. and 5 p.m, then we say it's axiomatic that an operator can't come onto the site at midnight and seek to lock trees. That is just obvious in our submission. By the same token, if the code agreement stipulates that the operator must comply with an access policy, say, for example, they're required to provide a risk assessment and notification of the individuals who will be on site prior to accessing the site, then again it goes without saying that that access policy must be complied with. During the course of argument yesterday, Mr Watkins sought to place reliance on the general nature of paragraph 3 of the code to say that because they are expressed generally, it's necessary to clarify that just because you've got a code right, that does not mean that you have an unlimited code right. Again, we say that doesn't take the matter any further. If I am given, under a code agreement, a code right of access, and the agreement says that I must access my telecommunications site using, let's call it access route A, it goes without saying that I can't access using access route B. That might go through, if we take the example of a farmer, that might have issues with livestock and fencing. I'd be a trespasser if I start just using different access routes. It doesn't give me a free right of access over any part of the land. So we say that stepping back, if that's all paragraph 12.1 did, then it'd be mere surplusage, simply spelling out the obvious. And it's hard to see why Parliament, in carefully crafting this new code, would have taken the time to state something so obvious.
I'm reminded that sometimes, at least in contractual interpretation, one forms a view, frankly, of the quality of the drafting, and arguments against surplusage have greater or lesser strength depending upon the view one has formed.
I appreciate that.
I wonder whether that is a legitimate tool in statutory interpretation as well. But anyway.
I take the point, my lord. So we say that, starting from the proposition, if we may then, that we assume that Parliament intended to do something with this paragraph, rather than merely spelling out the obvious. And we say that in support of that, in seeking to understand what paragraph 12.1 was intended to do, then it's prudent to look at its statutory predecessor, and we already did that during the course of argument yesterday. So that's paragraph 2.5 of the old code, my lord. Right. My learned friend, Mr Watkins, has already taken you there, but again, if I could please ask you to turn up page 496 of the authorities bundle. That's tab 20, it's still in bundle 2. Subparagraph 5 is actually over the page at 497. It reads as follows, my lords. A right falling within subparagraph 1 above shall not be exercisable except in accordance with the terms, in parentheses, whether as to payment or otherwise, subject to which it is conferred. And, accordingly, every person for the time being bound by such a right shall have the benefit of those terms. You will note, my lords, that the wording of that first clause before the semicolon is materially similar to paragraph 12.1, save for the inclusion of the words in parentheses, whether as to payment or otherwise. In our submission, what that wording in parentheses does is it signals that the effect of paragraph 2.5 of the old code was to ensure that those desirous of exercising code rights were bound by the terms of the code agreement, including the terms as to payment. So, put another way, and put rather more colloquially, if I may, the effect of paragraph 2.5 of the old code was that if an operator wanted to exercise code rights, then they had to pay the price. I appreciate, my lords, so that begs the question rather as to what that price might be. And in the course of argument, and I think in their supplemental skeleton, APW have suggested that it could be a reference to a fee payable for the exercise of a specific code right. Presumably what they have in mind is some sort of fixed fee that's payable for, say, every time you access, you pay X pounds per access. Our response to that is to say that such fees are not a common feature of code agreements, and typically the consideration, whether that takes the form of rent in a leasehold context, or a license fee in a context such as this, is payable for the bundle of rights as a whole, rather than being divided up in relation to specific rights. So, for example, it won't be X pounds per annum for the right to lawn trees and Y pound per annum for the right to install equipment. So we asked the question that why would Parliament, against that backdrop, when drafting the old code, have chosen to single out and legislate for that possibility? We say the short answer to that is it's more likely that what Parliament had in mind when we talk about payment is what we would normally expect payment to mean, which is consideration for the agreement. And so we say in that way, paragraph 2.5 of the old code supports our analysis of paragraph 12.1 of the new. Moving on, my lords, then to essentially my second proposition. Even if you're not persuaded that this is the natural and ordinary meaning of paragraph 12.1, then I return to my earlier point, and I say it's a possible meaning. And we say paragraph 12.1 should be interpreted purposefully. Mr. Lees has already devoted time to the purpose of the code and the policy aims underpinning it, as well as the approach that was promulgated by Lady Rose in Compton Beecham, and so I don't propose to repeat any of that here. There are just a couple of points that I would like to make in the context of that proposed interpretation. Mr. Lees yesterday, I believe, referred you to the DCMS report, but I'm not entirely sure he took you there. For your note, it starts on page 465 of the authorities bundle. That's bundle 2, tab 17. There is a ministerial foreword in the usual way by the then Minister Ed Vasey, who makes clear that the code is intended to provide, and this is his words, a robust platform to enable long-term investment by operators. That statement was cited in the opening paragraph of Compton Beecham, which, for the purpose of any note, is page 213 of the authorities bundle. It's On Tower's position that if operators are to invest...
Sorry, I didn't catch that. So it's cited in Compton Beecham in
very first paragraph, my lord.
Sorry.
It's in the very first paragraph of Compton Beecham, my lord.
Yeah. Yes.
If operators are to invest in telecommunication sites and to be encouraged to do so, which is the evident purpose of the code, we know that from the DCMS report, and we know that from the very first paragraph of Compton Beecham, then it's essential, we say, that the code is interpreted in such a way as to provide those operators with certainty as to their rights to assign and take assignments of code agreements in respect to those sites. Our case on paragraph 12.1, we say, has the benefit of both simplicity and certainty. For the reasons already canvassed by Mr. Lees, all you have to do, if paragraph 12.1 is the answer, is look at who is actually exercising those code rights. It's a factual inquiry, one that doesn't rely on documents that might not be in the possession of the party asking the question, and doesn't require you to go backwards in time to identify, for example, in the scenarios that Mr. Lees identified, where there might be coincidence of benefit and burden, even if that's for a relatively short time. Further, as Mr. Lees has already emphasised, On Tower accepts that it is bound by the burden of the code agreement. That has been our case throughout. Paragraph 12.1 has the advantage of providing a statutory mechanism which explains being bound in that way. And if I may posit a question, it's why would one seek purposefully to read that down? Surely, we say, it's in the interests of site providers that operators are so bound. I can see Mr. Watkin nodding, and yesterday he candidly acknowledged that it would suit APW if On Tower were correct in this regard. And we say, given that it is a possible interpretation, but I might put it neutrally, of paragraph 12, then it is the best solution because it serves both parties' interests. We actively want to be bound insofar as necessary for the purpose of renewal, and APW would like us to be bound as it guarantees their income stream. Earlier in the course of argument, my Lord Justice Newey pointed to the potential absurdity if we're left in a position where no one is on the hook, as it were, no one is bound by these burdens during the period of the statutory continuation that arises out of paragraph 30. We say paragraph 12 obviates that problem. And stepping back and looking at it as a matter of fairness, we discussed in the course of those questions the potential issues of retrospectivity that you could have, assuming that an original party to a licence isn't liable thereafter. For reasons of retrospectivity, it would be unfair if they never signed up to it. By contrast, if one's considering what's fairer, it's fairer in our submission that the person actually on the site exercising those rights is the one that bears the burden. And so it provides not just a solution, but also, we say, the fairer one.
Can I ask this? Does it have the effect that a sharer exercising the rights also becomes liable for all of the your sense of the obligations that condition the right?
We say it wouldn't, my lord, and the reason for that is that, and this relates back to what Mr Lees was saying earlier about the sort of blue on blue analysis and the operation of the code. We say that on our reading of paragraph 12, what one is concerned with is the code rights are being, it's essentially the code rights under the agreement. They are being excised by us because we have the benefit of that agreement. That's common ground. If we then allow someone else to use those, that the obligation or the relationship exists as between us and them. It doesn't affect their position.
Does that mean the sharer doesn't get the statutory immunity when exercising your code right?
I would need to think about that, my lord, but we say, I suppose, our position on paragraph 12 is that paragraph 12, taken as a whole, there is of course statutory immunity, which I'll come back to in a moment, but there is also, we accept that, spelling out the obvious, you're obliged to comply with any conditions for its exercise, and so we say that the operator, given that you are allowed to share under the code or under the terms of agreement, whichever it may be, depending on that, and you also yourself have this statutory immunity, then it's hard to see why you wouldn't have that benefit if there's someone that you are allowed to share with who comes on site. It would feel unfair to the sharer otherwise, and that's certainly an interpretation. We say paragraph 12.1 may be able to do a number of things, making clear, if necessary, that you are bound by any terms, although we say that's not necessary, but it also makes clear that you are bound by it. We say the fairness would be that you are entitled to be there, you're entitled to share, you're entitled to renew, and you all have the benefit of any statutory immunity if need be. And we say that can be accommodated. But I'll give that specific thought over the lunch adjournment and come back to it, my lord. Mr Lees has already highlighted a code agreement may be a lease or a licence, and regardless of the means by which code rights are conferred, the particular wrapper parties choose, it's common ground that code rights are transmissible, and that On Tower has the benefit of those assigned code rights. We say that's the background against which Parliament was legislating when it enacted paragraph 12.1, and we say that our interpretation has the benefit of equalising code agreements by ensuring that an assignee operator is bound regardless of the particular wrapper the parties have selected. That should avoid the need to inquire as to whether it is a lease or a licence and avoid some of these thorny questions. The other thing we say in terms of maintaining that symmetry and equalising things is that if one is to read paragraph 12.1 in this way, then it maintains a neat symmetry of paragraph 10.3 of the code, which we've already looked, my lords, by ensuring that successors in title of either party are bound going forwards. As was explained in the GenCom by my Lord Justice Newey, what paragraph 10.3 does is ensures that there's your operator isn't left in a precarious position because the person who has come in, the incumbent site provider, isn't bound to respect those code rights. We say paragraph 12.1 does the exact same thing in reverse, and therefore ensures that both parties' positions are respected. I wonder, my lords, if this might be a
just
convenient
a
point for me
just
to
let me
stop.
write down what you said, and then we'll give up.
Thank you very much, my lord.
So thank you very much. 2 o'clock.
Right.